Call to order the regular meeting of the Oakdale Planning Commission, April 4th, 2024. Roll call, please.
Yes, Pearson.
Here.
Willenbring.
Here.
Campbell.
Present.
Stolarski. She said that she's going to be absent this evening. McCauley.
Here.
Diata.
Here.
Hagan.
Here.
And Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we do the approval of the agenda, I'd like to offer an amendment, if I can, to move council liaison update to item 6A, if you will, after the open forum. Do I have a second?
Second.
All those in favor?
Aye.
Aye. Any opposed? Thank you. Approval of the agenda. All those in favor, as amended?
Aye. So
Aye.
moved.
Do you need a
Whatever
motion?
you need.
Need a motion. Second, then?
Second.
Thank you. All those in favor?
Aye.
Any opposed? Thank you very much. We have open forum. This is the time when
You have to approve the minutes.
approval of the minutes. Thank you.
Yeah. And I will abstain from that as I was absent last meeting.
Okay. Does anyone have any amendments to the minutes or a motion to approve as presented?
Move to approve as presented.
A second.
Any discussion? All those in favor?
Aye.
Any opposed? Thank you. Motion passes. And now the open forum. Open forum is a time when people can come forward to make comment to the Planning Commission and to staff. If there's anybody in the audience who wishes to come forward to make comments now, please do. Seeing none, I'll offer it one more time just to be sure. And if anyone wishes to come forward, please do. Close the open forum. We have no old business, so the first item of new business is a public hearing for Heidi Hoffman, 2872 Hallmark Avenue North, a conditional use permit for an accessory apartment. Max, I understand you're the one in charge.
Certainly. Thank you, Planning Commission, and good evening. Tonight in front of us, we have a request for a conditional use permit regarding an accessory apartment at 2872 Hallmark Avenue North. This property is located between Hadley Avenue, 28th Street, and I-694. It is zoned R1 for very low-density housing, where accessory apartments are allowed via the conditional use permit process. The purpose tonight is to take a look at the permit application to enable the property owner to construct an attached separate dwelling unit onto their existing single-family home. The purpose of the attached dwelling unit in this case is to allow the applicant to live with her sister. For reference, accessory apartments in Oakdale function very similarly to what many other cities refer to as an accessory dwelling unit, in which property owners are permitted to allow smaller second dwelling units attached or detached from single-family properties if certain criteria are met. These units are sometimes referred to as mother-in-law suites or granny flats. The applicant's site in this case is approximately 1.1 acres in size and contains a roughly 1,700 square foot single-family home. So here we have a more detailed look at the applicant's plans to add an accessory apartment. The existing home is outlined in the hatched area, and the proposed accessory apartment is shown on the left and rear sides of the house, or the south and western sides. Based on the provided measurements, the proposed addition would meet all setback requirements in the R1 district. Here we have a more detailed view of the proposed expansion. The extent of the new accessory apartment is highlighted in green by city staff. Within the accessory apartment, the applicant shows a new garage, a kitchen, a living area, one bedroom, and a bathroom. The proposed apartment is smaller than the footprint of the existing house and is designed to appear accessory to the primary unit. I'll zoom in a little bit to make it easier to see. Here we have a sketch by the applicant of the proposed accessory apartment. Based on the drawing, the applicant shows the apartment as being primarily on the left and rear sides of the house with an additional attached garage. This image and all of these figures are also available in your packet. So as a reminder, conditional use permits are subject to certain review criteria found in the city's ordinance. Here's a quick summary of the review criteria that we must use in our evaluation. General compliance with the comprehensive plan, compatibility with zoning, no nuisance effects being generated, no traffic congestion or parking issues. Use must be adequately served by public services and infrastructure, minimal impacts, as well as minimal impacts to the environment and natural features. Specific criteria for accessory apartments include that the apartment must be a complete and separate housekeeping unit. Only one apartment can be created within a single-family lot. The property owner must occupy at least one of the dwelling units. The accessory apartment must be designed such that the appearance of the building remains similar to that of a single-family residence. The design must conform to all health and building code standards, and at least 3 off-street parking spaces must be provided for use by residents. Generally, staff finds that the conditional use permit review criteria in this case has been satisfied as detailed in the staff report on file. Staff recommends approval of the request, subject to the following conditions. The owner of the residence shall occupy at least one of the dwelling units on the premises, except for bona fide temporary absences. The use shall conform to the criteria required under the City of Oakdale Code of Ordinances, Chapter 25, Article 6, Section 2523C3. A building permit must be obtained for the use. The property owner shall verify with the Metropolitan Council if sewer availability charge fees are required as a result of the expanded use. And the accessory apartment, including the additional garage, shall not exceed 1,600 square feet in size. As a reminder, this is a public hearing, and the applicant as well as the builder are here in attendance with us. With that, I'm happy to answer any questions, and thank you.
Thank you, Max. Does anyone have any questions for Max on his report?
Not at this time.
Seeing none, I'll offer the time to the applicant to come forward for any comments they wish to make before I open the public hearing.
I don't know that, so I'm Denny Mintz, represented Heidi Hoffman and Helen as the owners. I'm the builder. I guess the only comment we'd make is we appreciate your consideration. I know that this addition would be just a real blessing to Heidi and to Helen as they're looking for accommodations, obviously much closer together and to be able to support each other in this phase of their lives. So, thank you.
Anyone have any questions for him?
I do have a question.
Go ahead.
Could you pull up the site plan you showed earlier? Yeah. Okay. The new garage there. Are you looking at expanding the driveway?
The driveway won't really be expanded other than the fact that there will be a concrete apron that will attach the new garage to the existing asphalt driveway.
Okay. I see.
So really, I don't know if you'd consider that an
So you come in
expansion. but-
you go in straight and then make a left into the garage?
Yep, you'd come in and then you'd have to make a left into the garage.
Okay, all right, got it. Thank you.
Of course.
Any other questions?
What's the plan from the exterior material-wise to tie those two buildings together? I presume you're not, reciting the existing structure.
We won't reside the whole structure, but we're gonna do like-for-like material, and then we're gonna do as best as we can for a color match. If not, if we're not satisfied with a color match, then we may work with Heidi and Helen on doing something complementary that's gonna be in same style and look cohesive to the building, essentially. So we want to pull it together, but on a color match with siding, as you know, it's not, that could even be more jarring than picking a complementary color, so.
Any other questions? I thank you very much.
Great, thank you.
And I'll open the public hearing. Like, as was stated before, it's time for anyone who, in the audience who wishes to make comments to come forward. If there are any, please do. And I'll offer a second time, if there's anyone in the audience who wishes to come forward to make comment, please do. Seeing none, I close the open forum, public hearing. Bring it back. Any final comments? Then I look for a motion.
Move to approve the conditional use permit for an accessory apartment at 2872 Hallmark Avenue North.
Second.
All those in favor?
Aye.
Anyone opposed? Thank you very much. Motion is approved. Now for the advisory body, we skipped right by Jake. You wish to come forward and make comment, Jake?
Not comment, but I have nothing major to report, but if you guys have questions, I'm happy to at least try to answer them. All right,
none?
and
Thank
just
you.
an FYI, I will not be staying for the training tonight. Well, I'm a little bit of a wily veteran when it comes to planning, I would say. So I don't know everything, and I never will, but I've got some experience, so. Thank you guys, and enjoy.
Thank you.
Thank you. Thanks. And now for the advisory body training. General topics presented by the City Administrator, Chris Volkers, City Clerk, Sara Ludwig, and City Attorney, Jim Thomson.
Hi, Mr. Chair, Commissioners. Thanks for having us today. With me is the City Clerk, Sara Ludwig. She's going to do a good part of the presentation. So we're going to kind of bop back and forth here. What we're doing is the council asks that we take more of an active role in providing consistency from the commissions as far as the agenda preparation, which you noticed a change in the last year about on what the agenda looks like. So we've kind of modeled each commission after the same agenda. And they also ask that we do some training on Robert's Rules of Procedure, on proper, what the council has determined is a proper etiquette for public meetings. And then just to provide you more information and answer questions if you have any. So that's what we're here to do today. We also have Jim Thomson, our city attorney. He's going to talk about the parliamentary procedure and the open meeting law information for you, okay? So with that, let me see if I can figure, we have a new screen here. I see a new kind of thing. So thank you for everything you do. The council is very appreciative. We are just staff to support the council. The commissions are the council commissions. You are there to provide information and advice to the city council. As staff, we are just here to support your work. So anything you need, we need you to tell us because we don't know what we don't know, okay? Our agenda today will include, I'll provide some city information, just overall city. I think most of you are very familiar, but it'll be a good reminder. Boards and Commissions 101, that'll be Sara, we'll go over that. Meeting information, the legal information the city attorney will do, and then we'll wrap it up with me talking about communications and how we can support each other between the council and the commission and next steps. And we won't take too much of your time today because I know you have 2 trainings, so this is a big night for you. The city's mission statement and core values, as you can see on the screen, the mission statement's been in place for a very, very long time. I don't even know when they came up with the mission statement, but we do still use it, and we do quote it, we advertise it. And the city as a whole mission statement to meet the evolving community-wide needs of our citizens through the delivery of top-notch municipal services in a fiscally responsible manner. Everything we do is focused on that. We have 6 core values here in the city of Oakdale. When we do recruitment of new positions, when we do advertising for council vacancies, anything like that, we talk about our core values. We try to live, breathe our core values. Our staff are all very familiar with it. And I'm just gonna go through them really quick just to kind of focus the discussion. Respect, we serve and treat all people with respect, fairness, dignity, and compassion. Responsibility, we are a responsible steward of community resources. Sustainability, we enhance the environment and mitigate impacts on it to whatever extent possible. Excellence, we encourage and foster order, quality development, and redevelopment. Integrity, we adhere to a standard of values promoting diversity, honesty, and ethical behavior. Innovation, we're a learning organization to the extent that it adds value to our community. So with that, what you see on the screen are your very familiar council members, mayor and council, Mayor Zabel, Councilmember Herr, Councilmember Ingebrigtsen, who is the liaison for this planning commission, Councilmember Morcombe, and Councilmember Willebring. The organizational chart you see here is a functional organizational chart. What you see at the top is the city council. They, of course, are the policymakers. They oversee, they are responsible for the entire city. They have one direct report, me. As a result, then I report as I said, to them, and then all the divisions and directors report up through me. And that's how the functional org chart works for the city of Oakdale. You'll see you, very important part, right at the top, advisory commissions. You'll see the box up there, and then the city attorney is also through contract with the city council. This is what our city staff leadership, our directors right now. You've got Andy Gitzloff, who you're familiar with, Community Development Director. Laurie Polkerbeck is the Communications Manager. Kyle is the new Finance Director. He's been Finance Director since late last year. Kevin Wold, Fire Chief, Acting Public Works Director. Also, he's playing 2 roles right now, and he's loving that. Melanie Lee is our HR Director. Nick Newton is our Police Chief. And Julie Williams is our Recreation Superintendent. We have 3 vacancies. One, we have a city engineer vacancy. We have a new position, Assistant City Administrator. The last time an Assistant City Administrator was hired in Oakdale was 2018, or they left in 2018. So we haven't had one in, 6 years. So we're working on that. Public Works Director Jim Romanek, as you know, just retired. So that's why Kevin Wold is acting as Public Works Director, sorry. Boards and Commission, I'm gonna turn it over to Sara and then I'll be back.
Thank you, Chris, and thank you to the commissioners for allowing me to be here tonight. So yes, I'm going to talk to you tonight about the boards and commissions of the city. So the first slide here, we have the advisory bodies. So as you know, the city has 5 advisory bodies. We have the Tree Board, the Planning Commission, the Parks and Recreation Commission, Economic Development Commission, and the Environmental Management Commission. And each commission is assigned a staff liaison. We have, of course, you know, City Planner Luke McClanahan is the Planning Commission staff liaison. We have 2 staff liaisons for our Parks and Recreation Commission, the Recreation Superintendent Julie Williams, who you just saw, the Parks Superintendent Jeff Kusling, and then we also have Max Losi. He is the Community Development Specialist and the staff liaison for the Economic Development Commission. He also does assist with the Planning Commission. And then we have Community Development Specialist Hannah Dunn, and she is our Environmental Management Commission staff liaison. We do have 1 vacancy for our Tree Board staff liaison at this point, and the city forester will fill that role once they are hired. So the city has advisory bodies to advise the city council, but also to provide meaningful participation for residents. And advisory bodies also have guiding documents. So each advisory has a dedicated section within the City Code of Ordinances, and the chapter for the Planning Commission is Chapter 16. We also have a city policy, CC002, that's City Council Advisory Boards and Commissions, specifically dedicated to the practices and procedures of our advisory bodies. And then most recently, we developed a handbook that we will roll out very soon, and it will be a guide to the general policies and procedures that apply to all the city council advisory bodies, and your staff liaison will email that to you in an electronic format. Advisory bodies do a few things. They provide feedback on city initiatives, goals, and annual plans, and other matters. They provide recommendations to the city council. I know you're very familiar with that. And they also participate in city initiatives, projects, and events. The work of advisory bodies can be initiated by the board or commission itself, by the city council, and also the city administrator. Annually, each advisory body develops a work plan, and a work plan is a guiding document that focuses the work of the advisory body during the monthly meetings and also throughout the year. It can detail annual ongoing items or provide a roadmap for specific one-time projects. And the work plan is developed with feedback from the city council, which occurs during a workshop with the city council annually. And then once that work plan is finalized, each advisory body will formally adopt it at their meeting. So some things that advisory bodies do not do. They do not direct the work of city staff directly. They do not take any responsibility for financial performance of any city facility or program, as there's no financial authority. And they do not speak on behalf of the city or the advisory body without permission or discussion prior. There are a few special roles within the commissions and boards. So we have the chair, and the chair is elected annually at the first meeting of the year and is the presiding officer at all meetings. The chairperson is responsible for keeping the meetings moving, assuming everyone has reviewed the materials beforehand. The vice chair is also elected annually at the first meeting of the year and presides over the meeting if the chairperson is absent. The staff liaison, which I touched on a little bit earlier, is a staff member who has been assigned to the commission and board. They help with preparing the agenda, with taking the minutes. They also attend every meeting and participate in discussions as necessary. The council liaison is one council member who is assigned to each commission and board. They also attend the regular meetings, and they provide updates on city council matters or other city matters, and they also bring updates to the city council from their designated commission or board. And then lastly, we have an ex officio member, and that's a specific designation such as a student, and they are non-voting. And then here's a look at an annual calendar for the advisory bodies. So the first meeting of the year, as I noted, officers are voted in January or February, depending on the meeting schedule. There'll be an appreciation event with the city council, and at that event, there will be the discussion of the annual work plan. In July, something new that we're rolling out is a new member orientation, and it is also when new terms begin for the returning commission or board members. And then lastly, in the fourth quarter each year, you'll begin to work on your annual work plan. And then next, I'll talk about commission meetings and relevant aspects of those. So for the types of meetings, your most common type that you'll be familiar with is a regular meeting, and that's going to occur on an established cadence. When and where the meetings are, you know when your meetings are, but they're always going to be in our council chambers. First Thursday of every month at 7 p.m. The staff liaison takes the minutes along with other city clerical staff, and of course the meetings are recorded. Some key components of the minutes, and these follow Robert's Rules of Order. You'll want to note the meeting name, date, time, and place, who was in attendance and who was absent, the approval or corrections of the previous meeting's minutes, any motions that were made, including who made the motion and who provided the second, a summary of what happened, any other actions that took place at the meeting, and then generally speaking, you want to record what was done, not what was said in the minutes. The staff liaison prepares the agenda in consultation with the chair. Commissioners are asked to come to meetings prepared by reviewing the agenda and the materials that are provided prior to the meeting, coming with questions and comments, or even emailing your staff liaison prior to the meeting. And then the order of business is following along through the agenda items, which I'll touch on here on this slide. So each agenda is going to have our header, which will have the meeting type, the date, the time, and the place. And then the first item here is the call to order. So the chair will call the meeting to order. There will be a roll call, which shall be verbal, and all members' names shall be called out, even if they are not in attendance. And the staff liaison should do the roll call. And then the approval of the agenda as presented or amended. And the agenda is created by the staff liaison, as I said, in conjunction with the chair. There will be approval of minutes as presented or amended. There is a public hearing, which is unique to the Planning Commission as allowable by state law. The open forum portion, which I know is new to the commissions and boards agenda, it does need to follow our city policy MIS 014, and it allows for public comment. We do ask that the chair always opens the open forum, even if there may not be any members of the public in attendance. The Planning Commission review old business is any agenda item that was previously discussed and is being brought back. The Planning Commission review new business will be anything formally coming before the commission for the first time. And then in the other section, we have staff liaison updates, which are any updates provided by the staff liaison on other matters. Commissioner updates, which is time for the commissioners to provide any updates they may have. And then lastly, our council liaison update, which again, they can provide anything about the city council or other city matters. And then the last item is the adjournment, which does require a motion and a second. Attendance is important to perform the work of the commission or the board, and chronic absences may lead to member removal. Current commission members, city council, city staff, and staff liaisons all play a role in recruiting members, as ideally we would like the advisory body rosters to remain full. A quorum is the minimum number of voting members that must be present in order for an advisory body to conduct business. And if a quorum is present at the beginning of a meeting, the quorum must be maintained for the advisory body to continue to conduct business. Ethical and respectful conduct. These are some things to avoid. Speaking over or cutting off another individual, insulting, disparaging, or putting down people or their ideas, bullying other members by displaying a pattern of belittlement, or making demeaning, judging, or patronizing comments. We do ask that the chair maintain order throughout the meeting. And then also some ethical and respectful conduct in which to strive to. Always use Robert's Rules of Order. Treat people with courtesy, politeness, and kindness. Encouraging others to express their opinions and ideas. Listening to what others have to say, and then recognizing that there will be differences in opinion. The standards of appearance and etiquettes for the boards and commissions. Business casual dress is appropriate. Speaking clearly into the microphone to ensure the best audio quality. Do not speak until called upon by the chair to help maintain order. And then just a reminder to remain quiet when the on-air sign is turned on prior to the start of the meeting and then after adjournment. So with that, I'm going to turn the time over to City Attorney Jim Thomson.
Just advance. This.
And then I can do the YouTube for you.
Don't play it yet, but I'll call you and play it. Hi, evening. Hi, I'm Jim Thomson. I am the city attorney, as Chris said. I'm with Kenny and Graven. We're a private law firm that the city contracts with to provide legal services. So I'm here to help you through a few things. The main goal of my portion of the presentation is to make you aware, first of all, of Robert's rules, but secondly, aware of laws that apply to you now as commission members that don't apply to you in your private life. So when you become a commission member, there are new laws that actually govern you in your conduct of the business, and it's just important that you get an overview of them, not expected to understand all of them, just to know that these laws exist so that if you ever have a question about it, you can ask. So, so first of all, I'm going to, Robert's Rules, I'm sure you've been all looking forward to this presentation since you've been on the commission, because this can get pretty dull. But just remember one thing about Robert's Rules. The purpose of Robert's Rules is to assist you in running efficient meetings. It's not to put roadblocks in the way. It's not to, prevent you from doing your business. It's just the opposite. And, we hear stories about Congress and all these things that people do, and that's not the purpose of Robert's Rules. Purpose of Robert's Rules is to help you run, an efficient meeting. So rather than me talk on this, I'm going to play yeah.
Okay, so it's right up there.
Make it full screen.
Oh, no, I gotta pull it over. Okay, guys. Sorry, bear with us for just a moment. I got that far. Don't know how to pull it over.
No worries.
Rely on Robert's Rules of Order to ensure that all meetings run effectively. This video will go through the basics of Robert's Rules and how they work to make meetings more efficient. To keep meetings on track, all orders of business are organized in an agenda that lists the various items that will be discussed. At the beginning of our meetings, members will vote on the adoption of this agenda. Only after the agenda is adopted can the meeting proceed. At the core of Robert's Rules is the creation of motions, which are formal proposals for an organization's membership to take a stance or take action on a certain issue. To make a motion, you must first obtain the floor. To do so, you must wait for the chairperson to call on you after the last speaker has spoken. When making a motion, ensure that it is clear, concise, and stated in the affirmative. This is not the time to elaborate on your motion or try to motivate for it. You will get the opportunity to justify your motion during the discussion period. However, before discussion can begin, another individual must second your motion. Otherwise, it is lost. Note, you don't have to be in support of a motion in order to second it. Seconding simply means that you would like to see further debate and discussion happen. If your motion has been moved and seconded, it is placed before members for consideration and debate. The mover is always allowed to speak first and is given the opportunity to justify their motion. During discussion, only one speaker may speak at a time. At any point during the discussion, an individual can move to amend or modify a motion saying, "I move to amend the motion," followed by the changes they wish to make. After all discussion and amendments have taken place, members will vote by a show of hands whether or not they support the motion. If the majority of members vote yes, then the motion passes.
Are we allowed to ask questions?
Excuse me?
Is there time to ask a question?
Sure.
Okay.
Sure.
I'll wait till you're done to make sure you might answer it. So-
They need to do that. Yeah, can we get our presentation back up?
Okay, perfect.
If I want to just advance it with Sara. Sure, questions allowed. One thing, let me clarify just one thing on there. It said the vote is by a show of hands. That little presentation is for like a big body of organizations and not for smaller groups. And so it's a slightly different twist. Here, you don't vote by, you vote verbally. You don't vote by a show of hands. So I thought I'd clarify that. But I'm happy to answer any questions if it's okay with the chair as we go along.
Certainly okay by me? Pose your question.
What legal standing does, like if we make a decision in the affirmative, we say, yes, that person is allowed to do something, but the city council denies it. I just wanted to know what legal standing does a decision the commission makes? I mean,
Well, the commission is an advisory body, so the commission makes recommendations to the city council. So your actions are almost always recommendations. There may be something you take special action on, I can't think of it off the top of my head, but but the way the planning commission is set up in Oakdale, you're an advisory body to the city council, and all decisions you do make recommendations to the council, and then the council considers your recommendations and either follows them or takes maybe a different approach, but that's how that works.
so I have a friend who was on a commission in another city, and they said it was a lawyer, happened to be a lawyer. He said it was legally whatever the commission decided in that city was binding somehow.
Okay,
So maybe it's
so
different in
there
every
is,
city.
okay.
Just curious.
There are, cities can do different things, okay? Some cities have what's called a Board of Adjustments and Appeals, which is authorized by state law, okay? And in those situations, the Board of Adjustments hears certain appeals, they can hear certain things, and they actually do have authority to make final decisions, but they're always subject to appeal to the city council. So if someone were to come before a Board of Adjustments and ask for a variance to do X, Y, Z, the board can act on that in these cities that have these, okay? And those decisions by the board would be final, but are appealable to the city council. So it's a little different twist, and there are situations where some boards do make final decisions subject to being appealed.
If I might elaborate on that, I think the League of Minnesota Cities defines 3 different types of city structures. Our city structure does not have us as more than just an advisory board.
That's right, right. That's correct, but my guess is the meeting that you were talking about was probably one of these other kind of meetings, that they made a decision that can be appealed. That's my educated guess, so.
Thank you.
Okay, next. Quickly. Okay, the roles of a chairperson, I just see from the meeting already, chairperson, the chairperson runs the meeting. They preside over all the official meetings and make sure that it's run in an efficient manner. Ensure decisions are made in a timely manner, and, be careful not to limit discussions, and assuring that both board members and the public have an opportunity to be heard, just like you did tonight when you have a public hearing, and you're used to that. I want to go back to one thing on the motions I wanted to mention. Planning Commission is just somewhat a little unique. Usually you have a staff report that you prepared, and there's a recommended action in the staff report, so that really helps you make the motion. You don't have to make the motion that the staff says, but it points you in the right direction of, where we recommend approval, we recommend denial, we recommend approval with changes. So you kind of can take the lead from the staff report. If and when it comes time to make a motion, you could rely on the writing right in the staff report. All right, now a couple laws that you want to be aware of, but I'm sure you're already aware of this one. So it's the open meeting law. So as a public body now, each one of you are governed by the open meeting law, where before you were a planning commission member, you weren't. You didn't have to care about the open meeting law, all right? So what the open meeting law does, it prohibits actions from being taken at a, quote, secret meeting. It obviously ensures the public's rights to be informed and allows the public an opportunity to present their views before the public body. All right, so where does this all start off from? The open meeting law is a statute that governs meetings of public bodies, all right? You would think that a statute that governs meetings of public bodies would define the word meeting, but it didn't. It doesn't. It still doesn't, okay? So the statute that tells you have to have open meetings doesn't define the word meeting. The definition comes from a 1983 court decision that defined a meeting as a gathering of a quorum or more of the, well, I use city council here, or of the planning commission, which they discuss, decide, receive information as a group on matters relating to city business. Notice there's nothing in this says, and a decision is made. So some people think, well, it's not a meeting if we don't make a decision. That's not accurate, okay? If you're deciding, gathering information, discussing matters relating to public business, it's a meeting. The fact that you don't make a decision doesn't change that. Now, things change, and in 1983, no, we didn't have electronic gatherings. Nobody knew what they were. Now we all have them. So we have to be, I'm going to cover that just a little bit. And also, email devices didn't exist back in 1983. So first question is, do emails among planning commission members possibly constitute a meeting of the planning commission? And there's a conflict on this. It's a Court of Appeals decision case that says no, because emails are not meetings, just like writings aren't, and you can't violate the open meeting law using emails. That's, it's an unpublished trial, Court of Appeals decision. And that issue's still never been addressed yet by the Minnesota Supreme Court or by another Court of Appeals. But there's also a body, a state body that issues opinions. It's called IPAD. They issue opinions on things, data practices, and open meetings. And they've issued an opinion that says, yes, you have to be careful. So I'm not going to bore you too much with the details on this, but the O'Keefe case is the appellate court decision, and they concluded that email exchanges are not meetings because, and then they cite the 1983 decision I mentioned, the law applies only to in-person meetings. And the statutes on remote participation in meetings requires the public to be able to hear all discussion. This is the court's rationale, and therefore the legislature must have assumed that a meeting involved only oral communications. So,
Quick question.
yeah,
The way you verbalize it implies that this is true only for Minnesota rulings.
that's correct.
Are there not some federal court rulings that have been?
Okay, the Minnesota open meeting law is a Minnesota statute, so it only applies in Minnesota. There is a federal statute, which you probably heard of, it's called the Freedom of Information Act, and that governs federal documents. Now, a lot of times we see, I'm sure Sarah's seen it, somebody gets to submit, and say, I'm submitting a Freedom of Information Act. They really mean a Data Practices Act, which I'll get to. So, but the open meeting law is a state law, and it's a state law, but it doesn't govern the legislature, by the way. It only governs local bodies and school districts. They didn't apply it to themselves.
I refuse to make comment on that.
Okay, again, I'm not going to go into, the IPAD advisory opinion involved emails among members of a group, a joint powers board. It happened to be the gang task force, concerning the need for, and there was a press release, and they wanted to comment on it, so they all sent emails back and forth to each other to say, yeah, this is what we should say. The administrator of it said, okay, and they made a press release, and the IPAD said, that was a meeting. These emails back and forth were a meeting. So my advice is, we don't rely on the Court of Appeals decision too much, even though it's out there, because we think is it conservative? Yes, but it's also, the public wants work to be done in the public, right? So you don't want to be sending emails back and forth discussing, the business that comes before you. So our advice is, with respect to the open meeting law, treat emails or tweets or texts or messages or the next kind of electronic device that comes along, treat it like phone calls, all right? You wouldn't, if the chair were to get you all on a conference call to talk about planning commission business, I think you'd all recognize that's probably a meeting, right? I mean, so treat these like phone calls. Don't engage in email conversations, serial or otherwise, between more than one other commission member. Okay, a one-way communication is not a violation of the open meeting law. So if one of you sent an email to the rest of you, that's not a violation of the open meeting law, because it's not a communication back and forth. The problem is when you hit the reply to all button on your computer, that's when the problem starts, okay? Because now you are talking about each other. So be careful about that. Work through your staff liaison, just like I advise the city council to work through the city administrator, so to avoid that problem. One other thing, emails between commissioners and staff will almost always going to be public data, all right? So keep that in the back of your mind when you're writing emails. Just to say, whenever I'm writing an email, it's possible that, about city business, okay? Possible somebody might make a Data Practice Act request and ask to look at it. So just a word to the wise on that one. All right, Data Practices Act, because you're a commission member now, you get data, your agenda packet is government data now, okay? So you're governed by that. The thing to keep in mind that government data under the Data Practices Act is it doesn't relate to where the data is. It relates to the topic of the data. So if the topic of the data is a planning commission item and you text someone, doesn't have to be commission members, someone in public, and it's dealing with city business, that text message is now government data, even though it might be on your personal cell phone device, okay? Remember that, okay? Anytime you're dealing with a commission matter, a written recording of that, be it a text, an email, or anything else, is government data, and it doesn't matter whether the source of that is your own personal computer or laptop or phone, it is government data. Yeah, so government data doesn't depend on the location. It can apply also to all personal devices. All right, one little thing in the Data Practices Act that sometimes might apply to Planning Commission is one thing that you might get that is private data is complaint data. When somebody complains about a condition of property, the identities, which is the names, addresses, and any other information of persons who register complaints with the city concerning violation of state law or local ordinances concerning the use of real property are private. Now, most of these would come to staff, but it's possible as a planning commission member, you could get a complaint, I guess, about something that might be before you about a piece of property. Just remember that the contents of the complaint aren't private, as long as they don't identify who spoke, who said them. But the identity of the person making the complaint is not public, it's private.
Quick question.
Yeah.
Just curious, we don't email each other now, but if we did, do we have a retention policy that we got to keep that email for 7 years then? And if so, how are we supposed to do that?
Sarah's the expert. Okay. That's another law called Records Retention Act, okay, which is, the definition of records under the Record Retention Act is not the same definition of government data under the Data Practices Act, okay? So Sarah, correct me if I'm wrong, okay? But I don't think an email is considered a record that has to be retained under the Data Practice Act. So, yeah. So, different law, and my opinion is, no, you don't have to retain that, okay? I mean, unless you've been told that there has to be a certain record on the record. Now,
There was a case where they did draw in emails a couple of years ago.
yeah, the question is a Data Practice Act case or a Record Retention Act case?
Data practices, but records retention would fall into it.
Yeah, yeah. So, but we can follow up with that. I mean, that's a fair question, so you want to know that, okay?
I think one caveat on that is that as long as we follow your other advice of sending everything through the liaison, he becomes the data retention email, and it becomes
Well,
superfluous
that's true,
for us.
yeah. Okay, all right. So we got Open Meeting Law, Data Practices Act, and then there's two more. Conflict of interest. Whoops, I went too far. Going in. There we go. Okay. Another law which is basically any member of a body that has a financial interest in or who may receive a financial benefit from or as a result of any advisory body action would have if you have a financial interest in a matter, there is a conflict of interest, and you would need to, abstain and not participate in that if you have a financial interest. If you do have one, disclose it, and then abstain from discussing or voting on the matter. Now, we get questions from council members, but also, well, I don't have a financial interest, but it's my brother-in-law that's the applicant, okay? And hypothetically, that's not a conflict of interest, okay? That said, there are appearances of impropriety that you want to be careful about. So if you feel there's just an appearance there that is uncomfortable and you feel it'd be inappropriate for you to participate, you can do that. do it sparingly, because as your main job as a commission member is to vote on things that come before you, right? So you don't want to not participate, because that's what you've been appointed to do. But if you have a situation where there's, you know, a personal relationship, you can't abstain. Now, there's one other situation where you probably have to abstain, even if you don't have a financial interest. Let's say you're a president of a outside nonprofit group or something, and they come to the city, to you for some type of approval, but you're the president of that body, but you're also on the planning commission, but you don't have a financial interest in it. But the question is, well, when you vote, what hat do you wear? Are you wearing your planning commission member's hat, or are you wearing the president of the local organization hat? So in that type of situation, you would also potentially have a conflict of interest, even though there's no financial involvement. And then one last law, it's called the gift law, which before you became a commission member, you didn't care who gave you a gift, right? But now you do. And a gift, you may not receive gifts from an interested person in conjunction with your advisory body. What's an interested person? It's someone who would do business with the city. You know, if you ever have any questions about this, we just have to ask, because the gift law can be a little bit involved. But if somebody's giving you something and you're getting it, you think because you're a planning commission member, it's probably a gift, and you just should refuse it. So probably enough said on that, just so you know. So 4 laws: gift, conflict of interest, data practices, and open meeting law. And if you ever have any questions about them, don't hesitate to work through your staff liaison, and they can consult with me to, you know, get the advice you need. Thanks.
Mr. Chair, Commission, do you want to pause for a second and see if there's any questions? So we don't go too far down this path
Does
without.
anyone have any questions at this point?
I have a question. Could you explain just briefly on the difference between city administrator duties and mayoral duties?
I wish the mayor was here to answer that. Wonder what he would say. No, so the city, or the mayor and the city council, they are policy makers. They make the policy and set the policy for everything we do. They set policies, personnel policies. They set the city council policy. You heard about the boards and commission as a separate policy. They officially set that policy. They make the decisions and they follow the city code of ordinances for the city. City administrator, I carry out those duties. It's my responsibility to make sure that the 140 staff and I are doing our jobs and serving the public.
Okay, thank
That
you.
answer it?
I did have a question. Just to clarify, on the open forum, those are comments on non-agendized items.
Thank you, yes. That is the way the council has set that up. Yes. Anything else? My next part's pretty short, so if you have any questions, we can revisit that at the end, okay? In regards to communications, what we wanted to highlight for you is there are a lot of opportunities to get on our social media platforms and to share information with the residents of Oakdale. You are representing them as well by being on this commission. You'll see on social media, these are the links. It's also in your packet. We can send you the links electronic if that would be helpful. We encourage you to sign up for the Facebook, for the Nextdoor, Instagram, YouTube. All of these meetings are on YouTube. I think you all know that. That is actually how we do our minutes often, is we watch the YouTube video so we don't miss anything. So there is that resource for you as well, because the other commissions are all on YouTube, as is the city council.
So what are the loud booms that people are always hearing?
What are what?
On the Nextdoor app, they constantly talk about loud booms.
Booms.
I'm just
I
kinda
don't
joking.
know. What do they say it is?
I don't know.
Okay. I don't know. Let us know next time you see one of those if you're
Okay.
curious.
Yeah.
And again, our staff are here to help.
Kevin usually replies to them.
Who?
I think
The
it's,
mayor.
Oh, okay.
I think a lot of it is
He
the
does.
bridge reconstruction over on 4th Street.
Yeah, yep. The 4th Street, the gold line is really ramping up, so I imagine it. We've got, you see some high building towers going up. The impact, we got a lot of construction at Willowbrook, so it could be any of that with the cranes. Yeah,
It could be a truck hitting a pothole too, so.
Or it could be a truck hitting a pothole. City council communication, ways to stay informed regarding what the council's doing, because remember, you're advising the work of the council. So we've got the minutes, I talked about the YouTube of all council meetings. We've got the annual work plan that you work on, each commission works on, and then the council discusses it, which they've done for all the commissions at this point for the 24 work plans, a workshop. We have workshops for city council and we have regular meetings. The regular meetings are on YouTube. The workshops are more working. We're working through documents. We're discussing things. That's where your work plans went for a discussion by the council, and then they come back here for formal approval. Council liaison updates, you've got council member Ingebrigtsen, and he gives you updates, but it goes both ways. You should tell him what you want to or need from the council, and he also will share what he knows. So it goes both ways. Annual appreciation event, we've done the same for a couple of years. You had the dinner with the council, mayor and council, and then reach out to your council liaison. We just keep encouraging that, but that's why you have one. Communication with the public. So, we're hoping that you're promoting the work of the advisory bodies. It takes a village to reach our residents, and we need you to do your part too. Some tips for you: ensure that the decisions that are happening here are based on the decision of the group and not you personally, as you're relaying what's going on. Sara also mentioned that, but that's really an important role that you have. Okay? Social media, engage with the social media content. I mentioned that by reposting and sharing. That's really helpful. We've got a really active communications department now. We did not have that a few years ago. And we have that, and they're posting stuff all the time, relevant stuff, what's going on, things that are coming up. It'd be great if you could share and get that out there and help us with that. And just to support the work in general of the city and the commissions. The council appreciates it, staff appreciates it, and the residents appreciate it.
May I add one thing?
Yeah, of course.
In addition to all of the city social media pages, I know all of the council members have.
They do.
Certainly have Facebook pages. So I would encourage you, if you're on that platform at least, to follow them, and they
We'll
often are
add that to our
posting-
presentation.
They're often posting information about
Yes,
things and
Yes.
answering questions, so.
absolutely, thank you. It's very helpful. We'll add that to the presentation. Okay.
This is sort of an aside, but why are there 4 commissions and 1 board?
I don't know. I don't know. It's always been a board.
Tree board started out as a different group. And
Oh.
It was under, there was a definition of the board from, I don't think it was League of Minnesota Cities, but some other organization, and so it was organized that way. Originally, it was 1 member from each of the commissions was assigned to be on the tree board.
Oh,
I'm the only one who's left that was, actually came in that way.
and now it's really turned into an advice, a
commission.
commission. Yeah. Thank
So
you.
it's following all the same rules as a commission now, so.
You have a well-informed chair there. Yeah, thank you, Dallas. Yeah.
So I noticed that you don't have a human rights commission. Is it because of how the city set up?
We don't have what?
A human rights commission?
Oh, it's the council decides on what commissions they want, and it's in the city code, and every once in a while they revisit that. So let me give you an example. For example, they're now talking about a future commission maybe regarding arts and culture or something around that. That's where the discussion would happen on additional or different commissions. So if you're interested in why or making that suggestion, reach out to the council members. That's what they're here for.
Thank you.
Other questions on this? Okay, I think this is like my last slide almost. We want to encourage people with diverse backgrounds to apply for the Planning Commission. It's really important to have different perspectives, especially with what comes before you. Very important work comes before you, and you consider very important work, and you make very important recommendations. So having that diverse background is extremely important. So we ask for your help in that. As a Planning Commissioner, review Chapter 16. Sara mentioned that. I'm sure Luke can get that out to you, just a link to Chapter 16. Read it. It's about you. It's your commission. And it's not very long, but it's very relevant. So, annual mandatory training for new commissioners. We're not going to do this to you every year. We're going to invite new commissioners that are appointed July 1st to have a separate discussion. Well, they'll be required to have this training with us separately, but you won't have to go through it every year. If you want us to come back, we're glad to. For additional support, please reach out. That's what we're here for. So any further questions? Jim, did you have something else?
Just want to answer Commissioner Wilbring's question about the email. Sarah found it. Sarah found it. Emails are what's called transitory documents under the, now keep in mind, it's records retention. And so you don't need to retain them. Just to show you how government works, what they say in the Record Retention Act is you have to retain your email until you read it. So, now why you would, once you read it, you don't have to retain it anymore, okay?
I view it a little bit differently. I view it as until I delete it, which may be before I read it.
Yeah.
Because I delete about 400 a day.
So you don't have to worry about Record Retention Act. But if you have the email and you don't delete it, and someone says, I want all the city's records relating to XYZ, and your email relates to XYZ, we have to produce it. So if you still have it, we have to produce it, but you don't have to keep it.
In other words, delete everything.
To clarify one thing too, Jim did mention this, but I want to make sure kind of everybody heard it. You know, you won't want to be emailing each other because of open meeting laws, right? So that shouldn't be a thing. You know, there are open meeting laws about that. You could create a serial meeting. You don't ever want to do that. Go through your liaison. That's what he's there for. If you have something that you need to communicate with your other members or your other commissioners, that's what your chairs or your staff liaison's for, so you don't inadvertently violate open meeting laws. It's really important. So. Other questions? Thank you for your attention. Appreciate everything you do, and the council is very grateful that you sat through this, so thank you. I appreciate that.
Thank you.
Thank you. Next on the agenda is a planning and zoning basic training presented by Erin Perdu of Stantec.
Sure. I don't have an adapter for the, is the presentation by chance? Do you have the present? Like,
Yeah, we could probably pull it up.
Typically, the same code.
like I don't have an HDMI.
Gotcha.
I can get it over.
Can you just let her?
Yeah. I put it in full screen.
I think it's half plus one, but I'm not sure. I was going to ask that because he didn't define it
there
as
it is.
a description. Quorum can be different defined by the organization. So some are defined as 2/3, some are defined as half plus
Yeah.
one. Some are defined as half.
All right. Well, gosh, I'm happy to be here. Yeah, it's nice to see. I think I've met all of you. You were all on the commission last time I was here. Sorry that I'm coming at the tail end of the training you just received, and I'm about to give you some new training. Sounds like perhaps in future years we will just refresh the continuing commissioners every few years perhaps on this, and only new ones. But it sounds like we're going to start and get everybody on the same foot. So could I get the presentation up on the screen? There we go. All righty. Okay, so what we're going to go through, I have a few legal slides too. Not many, so we'll quickly go through the legal basis for what you do and the legal basis for planning and zoning, the roles and responsibilities of the commission. You got a little hint of that already. I'm going to spend most of the time on the rule books that govern what you do and the types of uses and applications that you see on a regular basis in your packets. So, to dive right in, the legal basis for planning and zoning. It starts all the way up at the U.S. Constitution. There are some key principles that relate to planning and zoning. Due process, which is how we make sure that everyone has a right to be heard and a right to a clear process before the government can say what happens on private property. Equal protection, make sure that we treat everybody in the same way. So that's why we have all these processes that you just heard about. There is also a takings clause in the U.S. Constitution, which says that the government cannot take all of the value of a private property without compensating the landowner. So that has some relation to planning and zoning, depending on actions that you take regarding land uses and permitted uses and things like that. It's pretty rare for a taking to happen, but just keep in mind that that's part of the reason that we write our ordinances the way we do. The Minnesota state statute also specifically enables city planning in this section 462.351. And it specifically says what city planning is supposed to do. So the job of your comprehensive plan and your zoning ordinances and all the actions you take are to help guide future development, create a safer, more pleasant, and more economical environment. And the one that you hear a lot is promote health, safety, and welfare. That's a key purpose of your zoning ordinances and comprehensive planning. So it's really, as we move through actions that you take, you're constantly balancing the police power that's granted to you by the enabling legislation at the state, meaning the city has a right to govern what happens on private property, but there are also individual rights that are protected by the Constitution. And so we're always acting in ways that try to balance those two things. So I won't get into more specific laws than that. But I do want to spend a little bit of time talking about roles and responsibilities. So my predecessors did this a little bit in general, but I want to reiterate the responsibilities of the staff. So Luke and Max and others that help provide you information, their role is to administer the planning process. So that means that they are the ones that have contact with applicants, with developers, with property owners who have questions. They do all the day-to-day work relating to that. They help guide people through the process whenever they are applying for something, or even if it's just a permit. They also prepare staff reports. And as Jim was saying, that kind of makes your job easier when you're taking action on something. Generally, the staff will lay out some findings of fact for you, and if you agree with them, making your motions is easier. But basically, they're there to give you technical advice. So your staff has education in planning, they have specialized training, they have made a career out of this. You have not made a career out of this. And so they're here to give you technical information and help you make informed decisions. And of course, they do special projects and long-range planning like your comprehensive plan and the Glenbrook Small Area Plan and other things that you've seen recently. Your role is one of the main roles that's mentioned in the state enabling legislation is that the Planning Commission is responsible for creating the comprehensive plan. Now, that doesn't mean that you and you alone approve it, but you're responsible for creating it. And you create it through having your staff and occasionally consultants help you with these things to do all of the technical work and recommend that plan for the community's future. You're also responsible for preparing ordinance amendments and recommending them to City Council from time to time. So, if there are changes that need to be made to the zoning ordinance, or I understand right now you've started the zoning rewrite process?
Yes.
Yeah, okay. So you're in the middle of this already, digging in and making some changes to the zoning ordinance. And as we talked about before, you make recommendations to the City Council on all land use applications. So your motions and your actions are recommendations to the council who has the final say. And that's how the charter is set up here in Oakdale. There are slight variations to that as we were discussing earlier. So more specifically, you all review and make recommendations on things ranging from the very general comprehensive plans and comprehensive plan amendments, all the way down to site plans, which are very specific and have very specific standards in your ordinance, and everything in between. So these are the types of applications that normally take up most of the space on your agendas every month. The City Council is the legal authority in city government. They are elected. You all are not elected. So they have the authority to adopt the comprehensive plan. They also adopt other plans, like Parks Master Plan is an example. And obviously they also control the budget for the city. So they have some financial responsibilities as well. But they also make decisions and approve or disapprove all of these various types of applications that you all see on your agenda. So they take the staff report information, they take your recommendations, and they put that all together to make their final decisions. Any questions about those basics before we kind of get into the meat of the rule books? Okay. I know you all have been here for a while, so I'll try to be efficient with the presentation. Okay, so the rule books that guide Planning Commission actions are mainly three things: the comprehensive plan, the zoning ordinance, and your subdivision ordinance. And so I'll give you a little overview of each of those things and how they interact with each other. So comprehensive planning in the 7-county metro area is mandatory, and that is by state law. Comprehensive plans guide future development for some time period, usually 20 years. We're looking out into the future. And it's essentially a strategic plan for how you reach the vision of what the city wants to be. Policies are broad brush, but they also form the foundation of the zoning ordinance. So everything that happens in the zoning ordinance has to be consistent with the policies and goals and objectives of the comprehensive plan. The comprehensive plan also includes a future land use map. I don't have a picture of that, but so it includes kind of where you think land uses should go, and the zoning map and the zoning ordinance should help make that happen. I'll talk about that a little bit more. So the role of the zoning ordinance is mainly to implement the comprehensive plan. It's as simple as that. But the zoning ordinance is basically the law that governs how you use land in the city. But the authority of the zoning ordinance is limited to what's in the state enabling legislation. So there are some specific things that you can and cannot regulate. But basically, the zoning ordinance has to have reasonable standards as a means to legal ends. So there are some reasons that people can challenge pieces of the zoning ordinance, but in general, it has to be reasonable, which is subjective, of course. So what can you regulate and what do you regulate in the zoning ordinance? We talk a lot about buildings, so that means setbacks, locations, how many are on a lot, what kind of materials you use in some cases. But we also talk a lot about things that have to do with lots. So coverage, how setbacks and how big your yard should be, uses, parking, all of that sort of thing is governed by the zoning ordinance. So it's much more specific guidance about what can happen on a parcel than what's in the comprehensive plan, which is more general. The Municipal Planning Act does limit your authority to regulate a few different uses, and they seem sort of like a hodgepodge of things. Manufactured homes, there's certain things you can and cannot regulate when it comes to manufactured homes. Earth homes is in there, oddly enough, and I'm not sure how that managed to get into state law. Temporary family health care dwellings, that came to be a few years ago, and those were sort of a precursor to accessory dwelling units. A temporary family health care dwelling in state law is defined as essentially a mobile home or a manufactured home that's on a lot that you let an ailing family member stay in. So again, very specific. Something that you're probably aware of is state licensed residential care facilities. So there are specific thresholds in state law that say you have to allow these facilities wherever you allow either single family or multifamily residential, depending on the size of the facility. So they're trying to prevent local governments from discriminating against state licensed residential facilities. You obviously have a zoning map. Similar to the comprehensive plan map, but much more specific, much more parcel specific. And you have a range of zoning districts. So this is the current zoning map in Oakdale, and they range from the red stuff, which is commercial, to the yellow and orange stuff, which is residential, and then a few, the industrial things, which are gray, and there are a few special districts in between. So every parcel has a district, and that allows you to go into the ordinance to see what's allowed in that district. So that's kind of how these things link together. There are a couple of other legal things that limit the authority of the zoning ordinance. There's something called RLUIPA, which means you can't burden religious exercise any more than you would burden any sort of assembly use. So this means that you can't discriminate against churches, synagogues, mosques, that sort of thing. The Telecommunications Act says that you have to allow antenna towers, and the ADA and Fair Housing Act say that you can't have different rules for buildings that house people with disabilities. So there are a few, again, federal laws that limit what you can do with zoning. Okay, then subdivision regulations. Your subdivision ordinance is actually separate from zoning, but it also governs what you can do on a piece of property. And the subdivision ordinance specifically gives you regulations that relate to lot splits and platting. It talks about parkland dedication or park dedication fees. But it gets into the nitty-gritty detail of things like street design and requirements for sidewalks and trails and easements and all of these things. So it's very specific about how land is divided. And so it has a pretty close link to the zoning ordinance also. Subdivisions do have to follow the regulations of the zoning ordinance. So they're linked in that way too, meaning that you can't create a lot that's smaller than what the zoning ordinance minimums are, for example. So basically the idea behind a subdivision ordinance is that you ensure that new development meets the standards for a safe, functional, and enjoyable community. Like I said, it has even more detailed requirements than the zoning ordinance and gets into all sorts of small details about how things are designed. So it does talk about, the zoning ordinance has more to do with what happens on private property. The subdivision regulations here talk also about the public realm, so right-of-way and boulevards and streets and things like that as well. So it was written by planners and engineers, so there's more detail engineering-wise in the subdivision regulations. Okay. And the uses and applications section is our last section, and it's probably the biggest. So I'll pause here for a second and just see if there were any questions about the links between comp plan, zoning ordinance, subdivision ordinance. That's pretty straightforward. Yeah.
Just a quick question.
Sure.
Like on the zoning map, what is row, R-O-W?
That's right of way. Let me flip back to that. Yeah, that's so the road rights of way.
What is a plat?
A plat is a legal document that subdivides property. So that's the simple answer to it, and there are more nuances. But basically, if you do something more than like split a lot into two, usually you have a plat. And the plat also talks about how each lot is described. So a plat is a combination of lots and blocks, essentially. So if you look up the legal description of a property, for example, and you find it's the blah, blah, blah subdivision, lot, block X, lot Y, that's part of a plat. And that's how most property is described in the city if you look up a legal description. There are a few exceptions, but mostly they're plats. Any other questions? Okay. All right. Well, then I'm going to go through the uses and applications that you see on a regular basis. I'm going to talk about uses first, because I think most of your work deals with various types of uses. The first way we describe uses are principal uses and accessory uses. So principal uses are kind of what you would assume they're the main or the primary use of a property. So typically principal uses are things like houses or apartments or offices or businesses, that kind of thing. So the main use of the property. But then there are also a whole host of accessory uses, and those are secondary or subordinate to the primary use. And that generally means that they can't exist by themselves on a property without a primary use. So there are some exceptions. Some ordinances allow, for example, parking lots to exist by themselves. I can't remember if your ordinance does that or not. Some ordinances have parking districts, for example. But things like garages or sheds or gazebos or ADUs are accessory dwelling units. Those can't exist by themselves unless they have a primary use also. Then we also talk about permitted and conditional uses. And the zoning ordinance has lists of these. Permitted uses are basically the by right uses that you have in your ordinance. So if you own a piece of property in an R1 or an R2 district, by right you could put a house on it. So permitted uses don't require any special approvals. There aren't any conditions that you can attach to it. So things like in a residential district, a house, or in a commercial district, a restaurant, or a retail store, things like that. But then there are more specific uses that we do call conditional uses. And those are the ones that I like to think of them as they require a little bit more scrutiny. They might have bigger impacts on the community. So for example, gas stations are a great example. So you might have a retail store like a clothing shop, but a gas station might have more impacts on the surrounding properties because there's lots of traffic. There's potentially odors and noise and all sorts of things going on at a gas station that's a little bit different than just a retail store. So usually gas stations are conditional uses because there are additional standards in the ordinance that they have to meet. And there might be things that you want to review and make sure they're okay for the surroundings. Drive-throughs are another great example. So a restaurant, it's a standalone restaurant, like a sit-down place, has a lesser impact on the surroundings than a drive-through because there's more traffic, there's stacking, we've heard stories about, Starbucks lines snaking out into the right-of-way, that kind of thing. So those usually have additional standards. And you are able to review those on a case-by-case basis and attach reasonable conditions to them, which is why they're called conditional uses. And I'll talk more about a conditional use permit here in just a minute. Then there are also interim uses, and interim uses are a great tool to have. Not every city has these in their ordinance, but interim uses are temporary. You can attach conditions to them just like you can with a conditional use permit. The difference is that they're interim uses by nature expire at some time certain. So that time could be attached to a particular business. It could be attached to an event. It could be a specific date. So those are permitted by state statute. And there are a few examples here, like mini storage. You might allow a temporary use of a parcel that's owned by MnDOT while they're constructing something, let's say storage of construction materials or something like that, whereas you wouldn't want to allow that forever, so you put an interim use on it. Solar farms are often interim uses because eventually their lease runs out. I put the outdoor play area for doggy daycare in here last time I did this training because a couple years ago you had, some of you remember this, you had a special use permit or an interim use permit because that was one of those uses that's like, well, we might want to allow it while there's a doggy daycare there, but if the business changes, you don't want that use to continue. So interim uses and conditional uses, there's another key difference here. Conditional uses, if you issue a conditional use permit, it runs with the land, so it's attached to the parcel. If you approve a drive-through on a particular parcel, it's attached to it. So, the McDonald's might go out of business and leave, and Kentucky Fried Chicken might come in and build another one and have a drive-through there because the conditional use is still there. They wouldn't have to come back to you for a new one unless they were changing something. An interim use does not run with the land, so you can attach it to certain, again, the time period, the business owner, something like that. So that's a key difference between these two and why you might use one versus the other. Legal nonconformities. So these are also types of uses. These are those things that we affectionately refer to as grandfathered in things. They can be uses, they could be structures, they could be lots. So it's basically any use or condition or lot that was legal when it was established, but at some point the ordinance changed and now it doesn't fit with the ordinance anymore. A common example of this is like a house that's built on a major thoroughfare. 50 years ago, they were all houses, and now they're starting to change to commercial, and maybe the zoning changed to commercial too. The house is allowed to stay there because it was legally built when it was built. But the zoning says it should be commercial. That's a legal nonconformity. And so, again, these are things that pre-existed the ordinance provisions. They're allowed to stay. So just because someone's house changed to commercial zoning does not mean that they have to get rid of the house. It's allowed to continue. It can be repaired. It can be maintained. It can be replaced. The only thing that you can't do is expand it. You can't expand a nonconforming use or a nonconforming structure. Another thing that you could have, there are a lot of legal nonconformities when we think about setbacks. So there might be a building that's in the required setback now, but when it was built, it conformed with whatever rules there were, or maybe there were no rules. And so you can repair, maintain, replace that structure. You just can't make the nonconformity worse unless you get a variance. And I'm sure you've seen some of those come across your desk. There are some state law provisions that require nonconformities to become conforming. If they're discontinued for more than a year, so if the use moves out and it's not used as it was for more than a year, when it's reused, it has to conform with the ordinance. Or if a building is destroyed by more than 50% of its market value and there's no permit to replace it within 180 days, which is 6 months. So they do give, if you have a non-conforming house and a tornado destroys it, you can rebuild it, but you have to get a permit within 6 months. So and those are state law things that show up in your ordinance also. Okay. If you have any questions along the way, just stop me. The planning and zoning discretion pyramid, I won't go through all of these things because we've talked about some of them already, but the point of this is that the base of the pyramid, the comprehensive plan, is where you and the city council have the most discretion. You can decide that the comprehensive plan is kind of your opportunity to decide what you want to have happen in the city. There's a lot of flexibility there for you to make decisions. The zoning ordinance has to comply with the comprehensive plan, so there's a little less discretion there. The comprehensive plan puts some guardrails on what you have in your ordinance. And then it goes up the line all the way to building permits where there's really hardly any discretion. Your building official reviews permits just to make sure that everything complies with the ordinance, but it's pretty administrative. It's pretty straightforward. It's when you get into these discretionary actions that things come before the Planning Commission. So that's why you all get paid the big bucks, is to have some discretion over things. Okay, I said I would talk a little bit more about conditional use permits. In order to approve a conditional use permit, these are criteria that come out of your ordinance. Every cities are slightly different, but they all sort of follow the same formula, and that is that the use has to be compatible with the surrounding properties or the existing neighborhood. It has to conform with the comprehensive plan. There's that health, safety, and welfare thing, so it can't endanger any of those things. And if the zoning code has additional standards for that particular use, it has to comply. So drive-throughs, again, for another example, there are probably standards in your ordinance that talk about how the lanes are designed and how much stacking space there is and where the drive-through is located, things like that. So they have to meet all of those standards as well. You can't revoke a conditional use permit once you issue it unless there's a violation of the conditions that you attach to it. And I have seen conditional uses revoked because there's some condition that says something like business hours, for example. you can have this use, but your hours have to be restricted to this time period because of negative impacts. You've got a neighborhood right behind you or something like that. If the business doesn't follow that, you could revoke the CUP. You can add reasonable conditions that are directly related to the use. So something like business hours is a common condition you might put on a conditional use permit. There are others. And again, all of this gets attached to the property and recorded with the county so that anybody who purchases the property knows that there was a conditional use granted for it. Interim use permit is somewhat similar. Again, it has to conform with zoning regulations. The unique thing here is that there's a date or an event that will terminate the use with some certainty. But otherwise, the criteria for approving an interim use permit are very similar to a conditional use permit. You just have some additional control there over when the use has to stop.
Question on that
Yeah.
versus conditional use?
Sure.
What latitude is there for the decision to make it an interim versus a conditional use?
It's listed specifically in your ordinance as either an interim use or a conditional use. So there isn't any discretion except when you write your zoning ordinance. So this process that you're going through right now, pay attention to that. Only specific uses are listed as interim, and then only specific uses are listed as conditional. So you can't necessarily just flip back and forth. So that's an important thing to think about when you're writing the code. Yeah, so again, some examples. Basically, a use that's associated with a special event or something that's tied to a particular business. You can't limit the time of a conditional use permit. In that case, you'd want to make sure to use the interim. And again, so that's why it's important to pay attention when you have that additional discretion in writing your ordinance to decide when you might want to use interim versus conditional. Okay, variances are always fun. Variances have their basis in state law too, so there's some stuff that's in your code and there's some stuff that's in state law, but basically someone who applies for a variance is trying to break the rules, or they're asking permission to do something beyond the rules. The general standard for whether or not you grant a variance is practical difficulty, and that's established by case law. And so we sometimes think, some of us remember when the standard was hardship. You had to show that there was a hardship to following the ordinance. Now the standard is practical difficulty, which is a little bit different. And I'll help you define that in just a second. So there is language in state statute that you have to follow when it comes to variances. So variances may be granted. The may is important. You're not required to grant a variance ever, but you can grant one when there are practical difficulties, and there are a few pieces to how you determine that. Whether or not the property will be used in a reasonable manner. So, for example, if someone in a single-family neighborhood wants to have a 3-car garage versus a 2-car garage, you could sort of look at the city as a whole and say, well, our 3-car garage is reasonable. You might say yes, and so that might be a reason to grant a variance. There are circumstances that are unique to the property that were not caused by the landowner, and that's an important piece. I'll go into some detail about unique circumstances in a second, and will not alter the essential character of the locality. That is actually in state law, and it's kind of awkward, but it basically means you're not going to ruin the character of the area where you're granting a variance. So, very subjective again. So let's talk a little bit about what is reasonable. So the owner wants to use the property in a reasonable way. Let's say they want to build a house in a single-family residential district. That's generally a reasonable use, but maybe there's something about the shape of the property or the topography or something that makes it a practical difficulty to meet the setbacks, for example. That would be a reason to grant a variance. It doesn't mean that the land can't be put to any use without the variance. It's just that you have to determine that the request is reasonable. Those unique circumstances that I mentioned. So unique circumstances generally relate to something physical about the property. So there might be a structure that's in the way of something that they want to expand. There could be trees or slopes or something natural that is an obstacle to meeting the ordinance. Or again, the lot is oddly shaped. That's a pretty common reason for asking for a variance. Something that is not a unique circumstance is economic considerations. So let's say meeting the conditions of the code would be more expensive for the property owner. That is not a reason to grant a variance. That's not a unique circumstance. The unique circumstance has to be something that is a characteristic of the property. The other thing that is not on the slide that I mentioned a minute ago is that it can't be created by the property owner. So property owners who build their own houses or have a house custom built on a lot, sometimes that prevents them from getting a variance in the future because they essentially created the situation that they might. For example, if someone custom built a house and built it so that it comes right up against the lot coverage requirement. So they've used up all of the impervious surface, all the pavement and whatnot. And then they come back and they want to add something later, a big basketball court or something. Well, they created the problem in the first place because they used up all of the lot coverage to begin with. So that's when it becomes you kind of created this situation yourself. So you'll sometimes see that. And that is not a unique circumstance. The character of the neighborhood. So some ways that you can make this a little bit more objective is to look at things like, is the result going to be out of scale with the rest of the buildings that surround it? Is it going to be out of place or inconsistent in some way? And you can look at height, setback, shape, orientation, something like that, to give you a sense of whether or not the request is going to be consistent with the character of the neighborhood. And then other general considerations. You can actually add conditions to a variance too. So if you grant a variance, you can add some conditions to that. They have to be directly related to and bear a rough proportionality to the impact that's created by the variance. So that's established by case law, and what that means is, for example, if you grant a side setback variance, you might add a condition that says you have to add some screening or a fence or something like that. What you can't do is add a condition somewhere else on the property, like that's not related to that specific issue that you're granting a variance for. Precedent comes up a lot when we're talking about variance. So some commissioners worry that if we grant a variance for this person to have 2 driveways, then we're going to have to do that for everybody in the neighborhood because we've established a precedent. That is not true. Precedent only applies to applications that are, the case law says, similarly situated in facts and in time. That the parcel has to be very similar, like almost exact. You are allowed to look at all of these on a case-by-case basis and determine whether they're appropriate or not. So granting a variance for one parcel owner doesn't mean that you have to do the same, make the same accommodation everywhere. If you decide in the course of granting a variance that, maybe the standards just aren't reasonable here, that's a time to go back and revise your ordinance, right? If you find yourself in a pattern of granting the same types of variances over and over, that's another signal that you should probably change the code because it seems reasonable to you that people should be able to do that. The other thing to keep in mind is that use variances are not allowed in Minnesota, so someone can't come in and ask for a variance to put a restaurant on a residential parcel. That's not allowed. And an error by city staff doesn't entitle a person to a variance. So, for example, if someone says, yeah, don't you feel good about that? It's, well, you know, like staff sometimes make mistakes, right? Like they might say, oh yeah, that's allowed. And so someone will go through the generating a plan and applying for a permit, and then they might catch the error later and say, well, wait a minute, that doesn't meet the setback, or you've violated this, that, or the other thing. That doesn't entitle the person to a variance. So you just have to review those just like you would any other type of application. Variances are kind of a big deal. So are there any questions about variances before I hit the rest of the applications? Okay.
Surprisingly, I don't think we see very many.
Really?
come
That's
through,
great.
yeah.
Well, your ordinance must be pretty good then.
I know, right? We have an amazing staff.
That too.
I've got one from putting a shed in because I had a tree in the only logical place I could put it, so I had to have a setback change.
There you go. So that's a perfectly good reason. Putting a shed on a residential parcel is a reasonable use. It's generally allowed. And there was something in the way of you putting it where you're supposed to put it. So, good example. Okay. Just a couple more of these before we wrap up. Zoning ordinance amendments. So not just in addition to a complete rewrite of your code, which you're looking at now, people, either residents or the city itself, can propose amendments or changes to the ordinance. They can be either changes to the text or changes to the map. Usually when you get a zoning ordinance amendment request from a property owner, it's usually a change to the map. They want to go from one district to another district. Text amendments usually come from staff, but not always. In order to approve a zoning ordinance amendment, a couple pretty simple criteria. The biggest one is that it has to comply with the comprehensive plan. It can't create any conflicts with the comprehensive plan. And it has to be able to be accommodating with by public services or not overburden the city's service capacity. So if you're looking at rezoning from, let's say, single-family residential to multifamily residential, one of the things that your staff and you will look at is, well, do we have sewer capacity to serve these additional residential units? And are the streets big enough to handle the additional traffic? That kind of thing. So whenever there's a map or a text amendment request, there's a greater burden on the applicant to show why this is necessary than on the government. And again, that relationship to the comp plan is very important. So you can't, spot zoning is a no-no. I think that means that you're taking one parcel and changing the zoning when everything around it is a different district. So you're creating a small island of something. You have to kind of stick with the pattern. There's nothing in the law that says that, but that's a general good practice to keep in mind. Those kinds of spot zoning requests don't come around very often. Usually, if you're reviewing a request and it's obviously on the map, it's creating a spot, there's usually some other criteria by which you might deny that. It's probably not consistent with the comp plan, or it might not be harmonious with the neighborhood, things like that. Here's an interesting thing to note that's in the Oakdale charter. It's probably that chapter that Chris was pointing you to. A rezoning from residential to something non-residential requires a 4/5 vote to approve. So not just a simple majority, but I guess the folks that wrote that wanted to make sure that you're taking those seriously and that there's some consensus around that. And yes, there's state law and procedures required for code amendments, so they have to come through to you and then to the council for final approval. And then comprehensive plan amendments. So these are big deals. Again, the comp plan is the guiding document for the city, but it can be amended in between those 10-year cycles when you do a complete rewrite of your comp plan. The Planning Commission has the state authorized responsibility to prepare and review and recommend amendments to the comp plan as you see fit. keep in mind that if you amend the comprehensive plan, and this is a look at your future land use map, you also need to update the zoning so that it complies with the comprehensive plan. That doesn't have to happen immediately, but if you do a comprehensive plan amendment, eventually the zoning needs to be consistent with that. So usually if you're doing a comprehensive plan amendment, it's because somebody wants to do something on a property that the city generally supports, but it's not consistent with the comp plan. So you're gonna go back to the basics, the base of the pyramid, and fix the comp plan to accommodate that use. And then you would naturally go in and change the zoning to be consistent with that. Something important to remember is that if there's a conflict between the zoning ordinance and the comprehensive plan wins, and that's by state statute. So what we mean by that is, in that example that I just gave you, if you are looking at the future land use map and someone wants to put a commercial use in one of the red areas on the map, which is designated for commercial on your future land use, and they come to you with a zoning map amendment, so that means that there's a conflict between what the property is zoned and what it says in the comp plan. In those cases, the comprehensive plan wins, meaning the zoning should match the comprehensive plan and the zoning should happen to commercial because that's what the comprehensive plan says it should be. That's what we mean by that. Okay. The last piece of this is just a few administrative things that I'm surprised Jim didn't mention. The 60-day rule, this is unique to Minnesota, but I think it's pretty neat because I have practice planning in several other states that don't have this. This means that if you get an application for a variance, a subdivision, a site plan, a rezoning, a conditional use permit, the city as a whole has to act on it within 60 days. And if you don't, it's assumed that the city has approved the application. There is a 15-day window whereby someone walks in with an application, your staff has some time to review it and make sure that the application is complete, that it has all the information that they need and that you need to make a decision on it. If it's incomplete, the staff has to reject the application and actually, in writing, tell the applicant what's missing and why it's incomplete. So the 60-day clock doesn't start until the application is complete. Again, as a general rule, if you don't act, it means you've approved it. The way that the city has set up your application timeline, there's a lot of care that was set up when we have like the application deadlines and then when it comes to the commission and when it goes to city council, so that the planning commission might take 1 or 2 meetings to evaluate an application if it's particularly complicated or that you have questions about and you send the applicant back to come and answer those. There's time built in. Yeah.
The 1 or 2 meetings came to play a couple of times where we went through the meeting, we said, this doesn't sound right, we need some more investigation from Luke or whoever was in charge at the time.
Yeah.
Does that reset the clock, or does that put the squeeze on the council to have to answer exactly on?
Yeah, it does not automatically reset the clock. But what you can do is you could keep the 60 days intact, and then, yeah, that would just leave less time for city council. Or the city, at its discretion, can make one extension for an additional 60 days without any particular reason. So the city can say, we need to study this some more. We're going to tack on another 60 days. And so that's what I was getting to. You just have to provide a written notice to the applicant that says, we're going to extend this another 60 days because we need further study, whatever. The other thing is that the applicant could also request an extension, and that's happened, I think it's happened here when I was serving as your city planner too, where you have questions, staff has questions, and they say, the application in its current state doesn't meet our requirements. We're either going to deny it or we recommend that you go back and make some changes. The applicant might say, okay, we need some more time. We're going to request an extension to that 60 days. So it could either come from the city or from the applicant. But the city doesn't need the applicant's permission to do that additional 60 days. If you want to do more than that, you do need the applicant's permission.
Can the applicant waive their right to 60-day?
No, but they could always withdraw the application. They could either withdraw the application, or they can say, I mean, essentially, they are waiving their right to 60 days if they say, we would like to have another 3 months to work on this. They could do that. So indirectly, yes, but there's not technically a, I waive my right to the 60-day rule. Okay, public hearings. So you basically need public hearings for all of the types of applications that come before you, from variances all the way through preliminary plats. The one thing to note here is that final plats do not require a public hearing, because usually you look at a preliminary plat, that's when you look at the substance of the thing. You might make some minor comments in your approval, but then the final plat is just they come back and they've made the changes that you requested, and that's more administrative, so there's no public hearing required for that. That does go through council, but doesn't require a public hearing. There are several legal requirements for how you publish notice. The clerk and staff handle all of the public notices, but suffice it to say that there's published in an official newspaper is required. That's starting to get difficult as local papers go away. And so I know that legislators are looking at ways to change that. There's a mailing that's involved, and then of course you allow public comment at your meetings as part of your agenda. Public hearings are important because of due process that I explained at the beginning, and due process is important because it's in both the US and the Minnesota Constitution. So this is why we do it. It's important to give people an opportunity to present their case, and for anyone who's concerned about the application to also make comments to you to consider. After you have a public hearing and you're ready to take action on something, you have to adopt findings of fact, and that's where the staff report is very helpful. The staff report should list some findings of fact to support your decision. And so basically you do that to articulate the basis and communicate to the applicant and to the public what your reasons for either the approval or denial. Here are some guidelines for findings of fact. If you're going to approve something, your findings of fact might include things like it's consistent with the comprehensive plan, it meets the definition of a practical difficulty, there are particular facts that support your decision. Things that are not valid findings of fact are, we like the guy, this person has lived here for a long time, or all of their businesses are really good, so I'm sure he'll do a good job. What's proposed is better than what's there now. None of those things are valid findings of fact. Your findings of fact should focus on the criteria that's in the code and how you think the application meets or doesn't meet those. So same thing with denial. If you're going to deny something, you would say that it's not consistent with the comp plan, or it does not meet the criteria of practical difficulty, or whatever the code says. Things that are not valid are neighborhood opposition, or you get a bunch of NIMBY concerns in the public hearing. That in itself is not a reason to deny something or approve something. But if concerned residents bring up something at a public hearing that is an issue with how the application conflicts with the code, that could be a reason, right? But the fact that people don't like it in and of itself is not a reason to deny something. Or the use or the business isn't what you prefer to see there. You've got to be more specific and tie it to the code when you make findings of fact. Yes, so you can't always vote the way the citizens want you to vote. You have to vote based on the rule books, so those things that we talked about earlier. So it's not always popular. And that's it. That's it. Do you have additional questions that came up? You've had a long meeting, so I understand if you don't. But Luke is always here if you do have questions about any of this stuff. I think the takeaway that I always like to leave people with is that staff is a great resource for you. And so please, by any means, run your questions through staff, but don't necessarily email each other about them.
We'll just email you.
You could email me or Luke or any, yeah.
Okay, anybody else have any questions for Erin before we move on? Thank you, Erin, we
Sure.
appreciate it.
Yeah.
Next on the agenda is the staff liaison update.
Oh yeah, sorry.
Yes. So just a few things here. I'll be very quick. So just a couple updates. The CUP, the Hendricks CUP for the second garage, that was approved by the council at their March 26th meeting. And then the other CUP for the residential hair salon, that was also approved by council at the March 26th meeting. So looking ahead to May 2nd, do plan on having a meeting for that date. We have a couple items there. We will begin the initial discussion for our zoning and subdivision code update. And then we will likely have one land use application. And finally, May 7th, hold that date. I believe you probably received a couple flyers already for the development bus tour, so we're excited to bring that back. That's all I have. Thank you.
Thank you. Any commissioners' updates? Anybody have comments? Seeing none, I ask for a motion to adjourn.
So moved.
Second.
All those in favor?
Aye.
Any opposed? We stand adjourned.